Hi everyone, the webinar is going to be starting in about 2 minutes. Good morning and welcome to today's webinar. Today's topic is foreclosure and loss mitigation and will be presented by shareholder Larry Rothenberg. Before we get started, I would like to take a moment to go over a few housekeeping items. My name is Hallie Schossler and I will be the webinar organizer for today. We want to make sure today's presentation is extremely valuable for you, so we ask that you submit all questions by clicking on the question button in the control panel and typing your question. Larry will use these to do a Q&A at the end of his presentation. At this time, I'd like to share a quick bit about Larry's background. Larry Rothenberg is a shareholder at Weltman and brings over 35 years of legal experience to the firm's Cleveland office. Larry practices real estate default, primarily focusing on residential and commercial real estate, complex foreclosures, eviction, and title insurance issues. He has been recognized with some of the industry's highest accolades, including Martindale, Hubble, and Ohio Super Lawyers. Without further ado, I will hand it over to Larry.
Thank you. We would ask everyone to please mute your phone to eliminate any background noise. And again, remember, if you have questions at any time, type them in the panel shown on the side of the screen, and I'll be answering those questions or most of those questions at the end of the presentation. And we'll try to conclude by 11:30 a.m. after all the questions and answers. So today's agenda, we'll talk a little bit about our firm. We want everyone to get a good understanding of the foreclosure practice, the foreclosure process, and the best practices for loss mitigation, how to gain possession after the foreclosure, and along the way we will try to highlight those areas where you can do certain things to try to improve your result. First, a little bit about our firm. We are a nationally recognized full-service creditors' rights firm. We represent creditors in real estate default matters like foreclosures, for example, evictions, bankruptcy, consumer and commercial collections, and commercial litigation and related litigation. We put a major focus on adhering to compliance in today's environment and security standards with a premium on reputation management that's protecting your reputation, the creditor, as we handle our cases. You're welcome to visit our website, weltman.com, to learn more about our firm and what we do. So let's talk about the things that you can do that can improve your results. First, when you refer your case to our firm, be sure to include complete information and all of the documentation to help ensure a clean case. In today's environment, we are being challenged by debtors' attorneys who try to find ways to cause delays or make claims or counterclaims or raise defenses in any way possible. And not only that, the courts themselves are much more aggressive in putting us under the microscope and putting our documentation under the microscope before the court will grant us a judgment. So the first thing is to make sure that your referral contains complete information and all of the necessary documentation. We want you to understand the process. In foreclosures, some states have judicial foreclosures, others have non-judicial foreclosures. There are even some states that have a blend. Here in Ohio, we have judicial foreclosures. That means a lawsuit, there's a judge, there's a complaint filed, a summons is served. The defendants have an opportunity to file an answer to admit or deny the allegations of the complaint or to raise any defenses or counterclaims that they may want to raise. That's a judicial process. Other states, Michigan, for example, have a non-judicial foreclosure process where in the foreclosure, there's no court, no judge, no sheriff, just a sale. And one of the big differences is judicial case is a long process. There's a long timeline to get to judgment. A non-judicial foreclosure has a short process to get to sale, but when it comes to concluding the case in a judicial foreclosure, here in Ohio, we have a much shorter period to obtain confirmation of the sale, to complete the sale. In a non-judicial state like Michigan, there's a longer process to before the foreclosure can be officially concluded. It is a very good idea for you to inspect the property regularly to see whether it is still occupied, whether it's even locked up and open. If it's been vacated, abandoned, and open, obviously you should be securing your property to protect it. And as part of your inspection, you should be determining whether this property still has enough value to justify completing a foreclosure. We have cases where we go through the whole process. Our clients incur all of the fees and costs and the aggravation to get to judgment, and then they finally realize the property is in such bad shape that they don't even have an interest in taking it to sale. It would be good to inspect the property before the foreclosure and during the foreclosure so you can make that decision before you incur fees and costs unnecessarily. You should be monitoring the real estate tax payments, and if they become delinquent, you should consider advancing funds because unpaid real estate taxes that become delinquent incur penalties and interest, and those amounts will have priority over your mortgage. And at the end of the foreclosure, there will be less funds available for distribution toward your recovery. You should monitor that the property has hazard insurance coverage. Most mortgages require your borrower to produce evidence periodically or upon your request that they have the property covered with paid up insurance. And if your property should become uninsured, you should maintain force-placed insurance when that's necessary. So if there is an event like a fire, for example, you won't have a total loss. You should be communicating with your borrower, obviously before the foreclosure, to try to find alternatives before you incur fees and costs for a foreclosure, but also during the foreclosure. There's no prohibition against you communicating with your borrower throughout the pendency of the foreclosure case and exploring whether they can find a way to make a payment plan or a loan modification agreement or other alternatives that are your best interests and will give you a better result. Prior to the foreclosure, we need to give attention to whether a notice of default, a formal notice of default, sometimes called a breach letter, is required. Some states require it by statute. In Ohio, on a first mortgage, there is no statutory requirement for a formal notice to be served as a prerequisite to foreclosure. However, Ohio did enact a statute within the past year, approximately 1 year ago, on a second mortgage requiring a specific notice to be served on the borrower in a certain size with certain language and so forth. That's a state statutory requirement. And even if you're foreclosing on a first mortgage, like I say, Ohio does not have a statutory requirement for a notice of default on a first mortgage. However, your mortgage itself, by contract, may require you to serve the notice of default prior to acceleration of the debt. And if that's the case, you must serve that notice and comply strictly with all of the requirements, with all of the language that's required. What we do for many of our clients is we handle the service of that notice of default to make sure that it complies strictly with all of the requirements. And it's very important because if you fail to serve that notice of default if it's required, or if your notice does not fulfill all of the requirements, even if you serve some kind of notice, that gives the borrower a defense to the foreclosure, which can be raised, and it can come to a head many months into the foreclosure case. And if the borrower has that defense and it's raised, there's really no alternative to dismissing the foreclosure and starting all over again with the proper service of a notice and then filing a new case. Some of our clients have asked a question about including attorney's fees in that notice, or, for example, the payment of the next monthly payment. So, for example, today is March 4th. If we're sending a 30-day notice to cure a default, requiring that the borrower cure that default by 30 days from the date the notice is delivered, that runs beyond April 1st. So can the notice include, as part of the amount that's required to be paid, the payment that's due on April 1st? The answer to that is no. If we're sending a notice today, March 4th, we can only require the borrower to pay what's due today, March 4th. And if they do pay what's due today, even if they pay that amount after April 1st, that fulfills the curing of the default that exists today. There might be a new default if they fail to make that April 1st payment, but that would require a new notice. And attorney's fees are not includable in the amount required to cure the default prior to acceleration of the debt. We ensure that our firm complies with the Fair Debt Collection Practices Act, and also we check for military status in case the borrower has is on active duty in the military service. You should be doing the same, making sure that you're in compliance with the Fair Debt Collection Practices Act. As far as the Service Member Civil Relief Act is concerned, even if the borrower is on active duty in the military service, it doesn't prohibit the commencement of a foreclosure or any kind of debt collection action. However, before the court can enter a judgment, that's where it comes into play, and that can cause a delay at that point. So let's talk a little more in detail about the referral to our firm. Like I said before, be sure to include all pertinent documents and information, and that would include complete copies of the signed note or the line of credit agreement, and the recorded mortgage, and any loan modification agreements that might have been signed at any time. There might even be more than one, but be sure to provide us with all of those documents. It's important to include any endorsements of the note, which an endorsement is actually on the note itself, but the copy that you're providing to us should include any endorsements. Also, any allonges, which are a separate page attached to the note, transferring the ownership of the note, and also any mortgage assignments, so that we have documentation to show the court and all defendants a complete chain of title to prove that we're the party entitled to enforce the note and the mortgage. The loan balance information that your referral will provide should include the principal balance, the current interest rate, the date from which interest runs, any variable interest rate changes since the date of default, and also the amount required to cure the default as of the date of your referral. Provide us with the Social Security number of the borrower. We keep that strictly confidential, but we do use it, and it is beneficial for skip tracing, finding the location of the borrower using our resources. Also verifying whether the borrower may have filed bankruptcy, and also whether they may be on active duty in the military service. And also when we get the title work, especially if you've got a common name of a borrower, there are undoubtedly many liens that will be shown against John Smith or Robert Brown, common names like that. And using the Social Security number, we can help the title company eliminate liens that don't relate to our borrower, especially governmental liens, and that would facilitate the foreclosure and speed up the process. Give us the borrower's mailing addresses if they're different than the secured property address. And also, if you have information that the borrower is married, they may not have been married when they signed the note and the mortgage, but if you have information that they're married now, give us the name of that spouse if you have it and the spouse's mailing address, because in Ohio, a spouse has a dower interest. Ohio is one of the few states that still has dower, and that makes them a necessary party in the foreclosure case. We need to name them either in their actual name if it's known, or if it's unknown, we name an unknown spouse. But we still want to name the spouse in the case to eliminate that dower interest from the title so that we'll have a clean title at the conclusion of the foreclosure. If you know the property is occupied by any tenants, give us the names of the tenants. Not every firm does this, but we name any tenants of the property as parties in the foreclosure case, not because it's helpful to the foreclosure case, but because it is helpful to the eviction that will be filed after the foreclosure. It speeds up the eviction process, and that's the reason why our firm does it that way. If you know that the borrower is deceased and you have the names and mailing addresses of any known heirs, provide that to us with your referral, because upon the death of the borrower, their heirs automatically have a vested interest in the property, and they are necessary parties to the foreclosure. And finally, in your referral, give us specific instructions. You want us to foreclose, you want a money judgment also against the borrower. If you want us to prepare the notice of default for you and so forth, give us express instructions in the referral. Once we receive the referral, we set up our file and we immediately will order the preliminary judicial report. That's a term that's used in Ohio for a title guarantee for a foreclosure case. It has a different term in other states, but that's what it's called in Ohio. The preliminary judicial report guarantees the accuracy of the information provided, but it only covers matters that are shown in the county records. And there are many items that might not be shown in the county records that will not be covered by the preliminary judicial report. But the preliminary judicial report does show the names of all owners, any lien holders who have filed liens, and if there are any possible defects in the lien, for example, a mortgage was not properly notarized or executed by the wrong party, or contained an incorrect legal description or something like that, that will be shown in the preliminary judicial report. And it will also advise us of any pending actions to the property, for example, a probate case, a bankruptcy of the borrower, or divorce filings, or I should also add a pending foreclosure filed by another creditor. Once we have the preliminary judicial report, we prepare the foreclosure complaint. Now, like I said before, it's very important that you provide us with all of the documents that we will attach as exhibits to the complaint, because the court requires us to show with documentary evidence that the plaintiff, our client, is the party entitled to enforce the note or the line of credit agreement and the mortgage. So the exhibits will include, like I say, a copy of the signed note with any endorsements or allonges, or the line of credit agreement, and the mortgage and any assignments of the mortgage. And for that matter, any loan modification agreements. Generally, the plaintiff must be in possession of the original note, but if the original has been lost, it's not a total loss cause. We can explain to the court that it was lost, but it's very important that if it's lost, the party who lost it was the party who was entitled to enforce it at the time. The foreclosure complaint also names the defendants. First, what are the claims that are in the foreclosure complaint? One could be for a money judgment in addition to a claim for foreclosure. In Ohio, unlike some other states, we can ask the court to render a money judgment in the foreclosure case, or we can only ask for a foreclosure and not ask for a money judgment. We wouldn't ask for a money judgment, for example, if the borrower is deceased, but even if the borrower is not deceased, we're not required to include a claim for a money judgment. We can file an action for a money judgment later or include it in the same case. We also, in addition to naming the borrower, we name any other obligors or guarantors of the debt if we're seeking a money judgment against them. So that's generally the first claim in the complaint if we're including a claim for a money judgment. The second claim in the complaint would be the claim for foreclosure. We name all parties who may claim an interest in the property, the present property owners, the heirs or unknown creditors if the owner is deceased, their spouses, like I said before, to eliminate the dower interest, all lien holders, the condominium or homeowners association if there is one. And again, back to the referral, if you know there is a condominium or homeowners association and have its mailing address, it would be helpful if you provide that to us, because sometimes it's difficult to identify that association and especially their mailing address. And we want to, if we have it, then we can perfect service of the summons on them in the first attempt. Many counties require that we name the treasurer as a party. Cuyahoga County does not. The treasurer is automatically included, even though not named as a party. But we do name any owners of any real estate tax certificates. We also, not every firm does this, but we also name any known or unknown parties in possession of the property. Like I said, not only does that make the post-foreclosure eviction more efficient, but it also provides you protection against the possibility that your borrower sold the property on an unrecorded land installment contract to another party. And if that other party is in possession of the property, they've got an interest, even though it can't be discerned by the recorded documents. So for that reason, we name the known or unknown parties in possession. That's another reason why we do that. If there's an oil and gas lease on the property, that lessee's interest will survive the foreclosure, whether or not they are named as a party. Therefore, they're not a necessary party to the foreclosure. We find this occurring often in some of the eastern counties in Ohio. Many oil and gas leases are in place over there. So in the foreclosure complaint, we make our allegations. We allege that we are the party entitled to enforce the note or line of credit agreement and the mortgage. And again, I can't emphasize it enough, that must be shown by the documentary evidence that we attach as exhibits to the complaint. We allege the loan is in default or the note is matured. The plaintiff was entitled to and did declare the entire debt due. Remember that notice of default we talked about earlier. That would be a prerequisite. So we state that we did fulfill any conditions prerequisite or conditions precedent to the foreclosure, and a recital of the balance due. In Cuyahoga County in particular, the court requires that we recite the principal balance, the interest rate, and the date that interest runs, not the payoff balance as of the date of the complaint. This court here does not want us to do our own calculation of the payoff balance. We allege the principal balance, the interest rate, and the date interest runs from, and the sheriff does the calculation when they're ready to disperse the proceeds. Like I say, we include a claim for money judgment if we want to. If the mortgage has a defect because the legal description contains an error or it was executed not in total compliance with the requirements, we can ask the court for an order reforming the mortgage or for a declaratory judgment to correct those defects. So all is not lost if there is a defect. We have ways to correct that in the foreclosure. Finally, we do include the claim for foreclosure. The next step is the service of the summons. So in order for the court to have jurisdiction over the defendant, in order to enter a judgment affecting the defendant's property, the court must acquire jurisdiction over that person. And the primary way for the court to do that is through service of the summons. If other ways that could occur are the defendant signing a waiver of service of the summons, or the defendant filing an answer without raising a defense of failure of service of summons. But primarily, we perfect service of the summons on all defendants in all cases. We do that by FedEx or by certified mail through the clerk of court's office. We simultaneously have a special process server go to the residence and try to perfect service of the summons in person by handing it to the defendant or by any adult at the residence. That also perfects service. One way or the other, we try to get service, and whichever one occurs first, that effectively gives the court jurisdiction to allow us to proceed. If certified mail is unclaimed, or if personal or residence service is refused, or if certified mail comes back refused, one of those three things might happen, then the rules allow us to issue service by ordinary mail. And service is then deemed complete upon the clerk of court sending the ordinary mail, as long as it's not returned as undeliverable. And finally, if we cannot locate the party's whereabouts with reasonable diligence, then we can issue service of the summons by publication. Service of the summons on the USA requires that we, if there's a federal tax lien, for example, we perfect service on the USA two ways, one upon the Attorney General in Washington and one upon the local district attorney. The term Lis Pendens is a Latin term, which means the thing is pending. We often find liens being filed after we have filed the foreclosure complaint. Those liens might appear on the updated title exam, called the final judicial report that we obtain after the complaint has been filed. But if there are any new liens that are filed, those parties are not necessary parties to the case, because based on the doctrine of Lis Pendens, their interests will be extinguished upon confirmation of the sheriff's sale. But if there are any new liens that were filed in that short period of time, which shouldn't be more than a few days, between the effective date of the preliminary judicial report and the date we file the complaint, those parties are necessary parties, and we have to amend a complaint to add them as parties. Many courts, or some courts, use mediation. They'll refer our case to a mediator and put the foreclosure on hold. If that should happen, we should request financial documentation from the borrower so that you can determine the most advantageous outcome, whether it's a payment plan, loan modification agreement, even a deed in lieu, and so forth. The mediator will conduct the mediation conferences to attempt to resolve the case, and cases that go into mediation often substantially lengthen the timeline, even if the mediation ends up being unsuccessful. We try to get the mediator to allow you to attend mediations by phone, so you don't have to take a day out of your time to attend those mediation conferences. Many times we can get the mediators to allow that, but if we do get the mediator to allow you to attend by phone, it's imperative that you be available by phone at that time. If we try to connect you by phone and get your voicemail, or you're not available or anything like that, the mediator can dismiss the case for that reason. So it's very, very important that you be available by phone at that time. While the mediation is pending, there's really no need to wait for the mediation conference to occur. You can be communicating, like I said before, throughout the whole foreclosure case to try to reach a resolution without even waiting for the mediation conference to arise. Defendants are generally allowed 28 days from the date of service to file an answer to contest the case or to assert an interest that they may have in the property. They can easily obtain an extension. They often do that, especially if they're represented by counsel. But 28 days is by rule, the time frame for them to file an answer. If you are a lien holder and you're served with a summons in a third-party foreclosure case in Ohio, it's mandatory that, just like the borrower, we must file an answer for you in the case within 28 days, because if no answer is filed for you, you will be found in default and the property will be sold free and clear of your lien. Your lien will be released upon confirmation of the sale, and you won't be entitled to any of the proceeds. So it's mandatory that any party who has a lien or any claim in the property file an answer within that 28-day period. So get those summons and a copy of the complaint to us with your referral information and documents, so we can be sure to get your answer filed before that deadline. If the 28-day period expires and the defendant has not filed an answer, we can then file a motion for default judgment, which would be an argument to the court that by not filing an answer, the defendant has admitted the claims of our complaint and therefore we're entitled to judgment. If they do file an answer, we can file a motion for summary judgment if we can show by affidavit or other evidence that there's no genuine issue of material fact requiring a trial. We can also obtain a consent judgment. Sometimes we can obtain the borrower's consent to a judgment, especially if it's part of a payment plan or something like that. And in cases that do present a genuine issue of material fact, those cases have to go to trial. Some courts use magistrates to process foreclosures. Cuyahoga County, for example, has magistrates who will handle the hearing and basically handle the entire foreclosure case and issue a magistrate's decision, which is presented to the judge. Defendants can file objections to the magistrate's decision, and then it goes to the judge to reject, modify, or adopt the magistrate's decision as the court's judgment. So courts that have magistrates can add a little bit of time, perhaps a month or more, to the timeline. The foreclosure judgment entry grants the money judgment if it's applicable, and also orders the foreclosure. It makes a finding as to our lien's priority, its validity, its priority, and the amount due. Any other liens are also recited as if they have filed an answer claiming a lien, the judgment entry will recite that they have done that. One question that I am often asked is, what about an IRS lien or a state tax lien or a condominium association lien? Are those liens entitled to priority over your mortgage? The answer is no. Those liens, like any other lien, take their priority based upon the date that they are filed with the county recorder or however they are required to be filed. So there is no super priority for those kinds of liens. If you have advanced funds for real estate taxes or hazard insurance premiums or for protection of the property, those are escrow advances, and if those have not been reimbursed by the borrower, we can include those in a supplemental entry after the sale. But it's important that you let us know that you have made those advances. So if we advise you of the sale results, for example, that's the time to advise us. You advanced certain amounts for taxes or insurance or to protect the property, and we can then include a supplemental entry to provide for those amounts. The defendants can file appeal to the Court of Appeals within 30 days after the judgment has been filed. If they don't do that, after the 30 days expires, they have waived their right to appeal. Then we get to the sale. In Ohio, properties must be appraised by the sheriff's appraisers. The minimum bid at the sale must be not less than 2/3 of the appraised value. Don't rely on the sheriff's appraisals. Their appraisers are not, they don't have any particular incentive to do a very good job. And so they might drive by and give it an eyeball and call it as they see it, but often it's not a true appraisal. So you should rely on your own appraisal, or if you a BPO even, not the sheriff's appraisal, in deciding how much you might want to bid at the sale. Ohio has a process that took effect in 2016 to authorize a private selling officer instead of the sheriff to sell the property. At the sale, the successful bidder is required to pay a deposit, but if you're the creditor and you're the successful bidder, that is waived by statute. When the sale is scheduled, a second sale is also scheduled. That'll be held later if there are no bidders at the first sale. No minimum bid is required at the second sale. So for example, if you choose not to bid at the first sale, and then there's going to be a second sale, keep in mind that a third party could end up buying the property for a minimal amount, paying only the court costs and the real estate taxes, leaving no amount available for you. So if we get to a second sale, you might think a little harder about whether you want to enter a bid. If there is a second sale and a third party is a successful bidder, you still have a right to redeem the property within 14 days. That's you, the mortgage holder, have a right to redeem the property within 14 days after the sale by paying the successful bid amount. Finally, we get to the court's order confirming the sale. The court will review the proceedings and enter an order confirming that the sale was conducted properly. In Ohio, the owner has a right to redeem the property by paying the total debt and costs until the court enters the order confirming the sale. At that time, their right to redeem is cut off. If there is a federal lien, like an IRS lien, there's a special right to redeem in favor of the United States, but I've never seen them actually execute or enforce their right to redeem. The deed is then filed. Some counties take longer than others for the sheriff to process the deed. And if there was a money judgment entered, then the creditor will have a deficiency judgment unless there's been a bankruptcy. The calculation of your deficiency judgment is the difference between the total debt and the amount realized from the foreclosure sale, regardless of what you might sell that property for at an REO later. So the deficiency is set as of the date of confirmation of the sale. You have a 2-year statute of limitations to collect that deficiency if the property was a residence for 2 families or less. So if you want to pursue collection of the deficiency, let us know right away and we can handle that for you. Also remember, if the debtor becomes deceased, we can present a claim for you to the decedent's estate to seek recovery of the deficiency from any of the estate's other assets. So let us know if you want us to help pursue those assets to try to make a better recovery for you. As we all know, a bankruptcy is an automatic stay on the foreclosure. We can get relief from the stay in the bankruptcy court, or if the bankruptcy court grants a discharge and the trustee abandons its interest in the property, or if the bankruptcy case is closed, then we're free to reactivate the foreclosure. And in a Chapter 13 bankruptcy, we need either a bankruptcy court order granting relief from the stay or a dismissal of the bankruptcy case. If there have been any prior bankruptcy dismissals within 1 year, let us know. You should know that some municipalities require that foreclosures be registered. It's really, in my opinion, a scheme to grab some money from the creditors. But if they have that ordinance, we have to fulfill that requirement and register those properties. Then we get to loss mitigation. So we're always seeking alternatives to foreclosure to try to get a better result for you than you could get from a foreclosure sale. So obviously reinstatement of the loan is usually the best result, paying it up to date. Forbearance and payment plans, loan modification agreements, short sales, a short payoff in the form of a lump sum settlement, a deed in lieu of foreclosure, or the borrower consenting to a private sale, or even a judicial sale, one way or the other. That's a friendly foreclosure, we would call it. A couple words about reinstatement. The borrower pays all past due payments, late charges, NSF charges, and the foreclosure fees and costs. So if your borrower wants to reinstate and ask for you for a reinstatement figure, don't forget to ask us for the foreclosure fees and costs that may have been incurred to that time, so you can include them in your quote to the borrower. After reinstatement, it's as if the default never occurred. The regular payments then become due. Like I say, include your attorney's fees and costs in the reinstatement quote, but in Ohio, in a payoff quote on a consumer loan, attorney fees are not recoverable. If your borrower wants a forbearance or a payment plan, we can put the case on hold while they make payments to catch up on their payments. During that process, don't waste the opportunity to get updated information from your borrower, their mailing address, other asset information. Those can be used in future collection efforts if they breach the forbearance and payment plan. And be sure that any agreement is in writing and signed by the borrower so you can avoid any misunderstandings. I cringe when I'm in court and the borrower says they told me on the phone I could pay $50 a month, and I just sent the first $50 payment, and we have no evidence to refute that. So be sure to have it in writing and signed by the borrower. Loan modification agreements are a modification of the terms of the loan. The loan number remains the same while the terms can change. If new money is lent or the interest rate is being increased, obtain an updated title search, because if there are any new liens that have been filed in the meantime, we want to ask the new lien holder to subordinate their lien to those increased amounts that might be included in your loan modification agreement. If your borrower proposes a short sale, be alert. Make sure it's a bona fide sale. Make sure that there's a title company involved that can provide you with a proposed settlement statement that you can review. Watch out for proceeds of the sale going to the borrower or a junior lien holder or an excessive broker's commission. And you can also require that the buyer sign an agreement that the buyer, being the buyer from your borrower, sign an agreement that there will not be any transfers within 30 days after closing. That's also a good way to avoid being defrauded on a short sale. In a short sale, you can agree to release the borrower from further liability, or you can simply facilitate the short sale by agreeing to release your mortgage while the borrower remains liable to you for the deficiency on your note. So you should consider, when there's a short sale proposed, can you get a better result than you would through foreclosure? Short payoff, lump sum payoff, is also an area where you should require that the borrower give you documentation to show their ability to pay. Can they pay a deficiency? So don't automatically accept a short payoff just because it'll be a simple way to get money quickly. If they propose a deed in lieu of foreclosure, we obtain a title commitment. I always recommend that you get a policy of title insurance in a deed in lieu situation, because if you remember when I talked about preliminary judicial reports, that is only a title guarantee that does not insure items not shown in the public records, whereas an owner's policy of title insurance would provide much better coverage for those risks. Consider the condition of the property and the possible environmental liability. If your borrower ended up using his property for a gas station, for example, that's a dangerous property at that point, because you could have environmental liability if you take ownership of it. And again, as part of the deed in lieu process, you can agree to release, give a full release of liability, or you can require your borrower to pay the deficiency based on payment terms. Of course, the borrower often would have little incentive to agree to pay the deficiency, but there are cases where the borrower would agree because it's in their best interest to do that. The friendly foreclosure, this is where they consent to allow a sale, either a foreclosure sale or a private sale using a broker or an auctioneer that you agree to. And this is usually in consideration of a partial release of liability for the deficiency. You might be served with a summons from a probate court if the borrower is deceased and their fiduciary files a complaint to sell the property in the probate court. You'll be served with a summons, and just like being served with a third-party foreclosure, refer those matters to us so that we can file your response and protect your interest in that case. Finally, just a couple words about post-foreclosure evictions. Remember that I said that our firm tries to serve a summons on the tenant or the occupant of the property if it's not the borrower, because then it entitles us to pursue a writ of possession. Cuyahoga County, for one, does not allow a writ of possession against a party who was not named in the foreclosure. That's the reason why we do that, so we can proceed with a writ of possession, which is a faster and simpler process than a municipal court eviction. Writ of possession is processed through the sheriff, and it doesn't require a court appearance. Be careful about accepting rent from either your borrower or the occupant after you have acquired title through a foreclosure, because if you accept a rent, you've just created a landlord-tenant relationship that imposes obligations on you and gives additional rights to the occupant. I often get the question about properties that are vacant, but household goods have been left behind. Don't assume that you can simply change the locks and you don't need an eviction at that point. Even though no one's sleeping in that property, if there's anything left of value or even arguable value, we should still complete the eviction process so that we can avoid any claim by the borrower that you either trespassed or stole their quality items when you did that. That brings us to the end of the presentation, and if there are any questions, like I said before, you can type them into the panel on the right. And I see one question, at what time can we change the locks for an interior inspection? This is the last thing that I said at the end of the presentation, actually. You can only change, well, let's talk about while the foreclosure is pending. If you inspect the property and find that it's been abandoned, you can change the locks at that time, assuming you have the usual form of mortgage, like the Fannie Mae Freddie Mac form mortgage, for example, or the usual form mortgage includes a right for you to protect your property by securing it. And so if you find your property is abandoned while the foreclosure is pending, or worse yet, unlocked, you're entitled to change the locks at that time. Now, if you buy the property at the sheriff's sale, even after you acquire the deed to the property, the borrower, as long as they still have anything of value in the property, the borrower still has the right to possession of the property until you complete the eviction process. So if there, like I said, if there is nothing of value in the property, just trash that no one could possibly claim had any value, you can change the locks at that time and you don't need to do an eviction. I recommend that anytime you do an interior inspection, you video the interior, walk through with a video camera going so you can have evidence as to what was in there or what condition it was in. So you will have evidence to refute any claims that the borrower might try to raise. One other question, what is the original note or line of credit agreement? I guess I should say, what if the original note or line of credit agreement is stored electronically, no original copy kept, right? So there are two kinds of loans. One is a promissory note, and the other is a line of credit agreement. The promissory note is the important one. If you store the promissory note electronically and destroy the original, that's a bad idea. You should retain the original. There are some courts that ultimately require you to produce the original. Not too many anymore. Cuyahoga County does not, most counties do not, and we can rely on a copy. But if a court requires that the original be produced, or if the borrower requires that the original be produced, we've got to produce the original note or explain that it was lost. If it was intentionally destroyed, that could be an issue. I know these defense attorneys, they would probably file a 10-page brief arguing why the note was not actually lost, but was intentionally destroyed, and then we've got to respond to that. So the bottom line is you should retain original notes in your vault, fireproof vault, in case they're ever needed. A line of credit agreement is different. That's not a promissory note, which is a promissory note is governed under the Uniform Commercial Code. A line of credit agreement is a contract that's not governed under the Uniform Commercial Code, so it does not have the same requirements for the original. Okay, and finally, a question, again, what is a judicial process in Ohio? So judicial means a court. In Ohio, a foreclosure requires a lawsuit. We file a complaint with the court. A summons is served. The defendants have a right to file an answer to assert any defenses to the foreclosure and to be heard. The judge then will enter a judgment and order the property to be sold. An order of sale will be issued to the sheriff or a private selling officer who will sell the property. That's called a judicial sale. And then the court will enter an order confirming the sale. And finally, the sheriff or the private selling officer records the deed. That's a judicial process compared to a non-judicial process like Michigan, for example, where there's no court, no lawsuit, just publication of the sale. That's the non-judicial process. And I believe that is the final question that has been entered. So it looks like there are no further questions.
All right, thank you, Larry, and thanks everyone for attending today. We will continue to have monthly webinars throughout the year, so be sure to check out weltman.com for upcoming additional webinars. Thank you, everyone.